This week, in a much awaited moment, the Supreme Court delivered a massive judgment concerning direct recruitment to the post of district judge. It consolidated three crucial aspects of judicial appointments and overturning some previous interpretations. The central argument from the Supreme Court's Constitution bench is a massive validation for in-service judicial officers. The court essentially stated that the experience of an assistant public prosecutor, a government pleader, or similar legal officers cannot be considered superior to the experience gained by a judicial officer who was already completed at least a year of rigorous training. The judgment, authored by Chief Justice B.R. Gawai, held that it is only merit and merit alone that shall matter. The court asserted that excluding these experienced judicial officers from direct recruitment violates Articles 14 and 16, that is, equality and equal opportunity of the Constitution. The judges questioned the logic. If government leaders who often practice before these very officers are eligible for direct recruitment, how can the judicial officers themselves be barred? This explicitly overturns the 2020 Dheeraj Moore judgment, which had previously prioritized the idea of a fresh perspective that an advocate brings. The ruling also addresses the misconception that advocates have an exclusive right to direct recruitment to 25% of the seats. The court clarified that while Article 233 Clause 2 of the Constitution mandates 7 years of practice for an advocate to be eligible, this provision only defines the minimum qualification for the bar's participation. It does not create an exclusive quota for participating advocates. The court emphasized that all qualified candidates, including eligible judicial officers, must be allowed to compete. Finally, the court rigorously defined what constitutes the 7 years practice that is required under Article 233 Clause 2. The Supreme Court ruled that this 7-year period must be continuous and uninterrupted as a practicing advocate. Therefore, any advocate with a substantial interruption in their practice, except for those who became government leaders, public prosecutors, or judicial officers, would be deemed ineligible. This is LiveLaw, and for detailed coverage of this case and more, visit us on www.livelawin.